Hi, I'm Jasmine Dillon and I'm a solicitor in the employment team at IBB Law. You may have seen in the news yesterday that a COVID antibody test to find out whether people have been infected with coronavirus in the past has been approved by health officials in England. As the country is slowly coming out of lockdown, this will inevitably beg the question whether employers can conduct tests on their workforce before admitting anybody back into the physical workplace. An employer cannot require an employee, worker or visitor to their premises to undergo a medical examination without their consent. To proceed without consent could potentially be a repudiatory breach of contract in respect of employees, entitling them to resign and treat themselves as constructively dismissed, and assault in relation to any individual. On a practical level, however, consent may not be an issue in the majority of cases, and employers may actually be reassured that their employer is taking steps to protect their health in the workplace. One of the complications which may arise from this is, what if the employee does refuse to consent to the test? If there is a contractual right for the employer to require the test to be done, which is probably unlikely, then their refusal to do it could be grounds for dismissal for failure to comply with reasonable instructions, although the employer may just need to tread carefully with this approach. In the absence of any contractual right, or if this approach is felt too high-handed or unsuitable for any reason, then we would probably be looking at an SOSR dismissal, which is dismissal on the grounds of some other substantial reason, unless of course there are any alternative solutions. Alternative solutions could include having the employee work from home, provided this is sustainable to the employer by reference to the particular job role the employee is doing. It may be, for example, that the employer could sustain home working for a certain period of time, but if the testing requirement were to remain necessary for a significant period of time and the employee continues to refuse the test, then an SOSR dismissal may need to be considered at that point. With an SOSR dismissal, the employer would still need to establish, namely, that A, there were no viable alternatives to dismissal, and B, the position taken by the company regarding the testing requirement is in itself reasonable. This latter part may be more difficult to establish, particularly if most other employers are not rolling out a testing scheme. But again, it may be that the employer can justify it by reference to the sector it operates in, public perception, health and safety, etc. Lastly, employers do need to be mindful of GDPR when it comes to processing the results of the test. So once the test has been completed, which is likely to be via mouth swab, the status of that sample is likely to have protected status as special category data, as the testing would involve the employee giving their genetic data and information relating to their health. The ICO has very recently published guidance on this matter from a GDPR perspective, which contains useful guidance on this issue. If you have any issues that you would like to discuss further, please visit our website, which is ibblaw.co.uk, and feel free to get in touch.